Good morning, sir. I'm Hendrix Arquerona, your student in criminal procedure and court testimony. To be honest with you, I know I'm late to attend your class, maybe one or two meetings that I late. And the topic I started is about preliminary investigation. So today, to be honest, I'll just say those I learned from the beginning to the end that we have studied. Um, So this is what I learned from Rule 112, which is the preliminary investigation, until Rule 113, which is the arrest. So preliminary investigation are investigation carried out before matter is prosecuted in court. And evidence has to be produced to establish whether the suspect committed the crime. And as well as determine whether is a sufficient evidence, and preliminary investigation are inquiries conducted by law enforcement officers in order to gather information about the accused person. And preliminary investigation are designed to establish whether crime was committed and to establish and identify the suspect. uh, Preliminary investigation determines whether to continue with the case or not to move forward. The process begins in the process with the preliminary investigation begins when a complaint is filed at police station. So the police officer in charge takes down the details of the crime and people who are related to the case. So, who are the officers or who are the officers conducted by preliminary investigation? So, the officers that conducted a preliminary investigation is a provincial or city prosecutor or their assistants, national or regional states prosecutor, and the officers may be authorized by law, like the police officer. So when the officer in charge get the complaint and he or she conducted a preliminary investigation. So within 10 days after the filing of the complaint, the investigating officer shall either dismiss it if he finds no ground to continue with the investigation. And maybe when if the fiscal believes there is a probable cause, he shall make the resolution and information, and he shall forward this resolution within 5 days to the provincial or city prosecutor or chief state prosecutor. So next, issuance of warrant of arrest. When a judge, upon receipt of the information, he or she see have a probable cause exists, and then he shall issue a warrant of arrest or committed order in the accused is already arrested. When the judge or he or she see a probable cause, he make a warrant of arrest to arrest the person who committed a crime. And when the suspect cannot be issuance without cannot issuance a warrant if he already under detention or already lawfully arrested, and he or she has a punishable by fine. So next, the arrest. Arrest is the taking a person in the custody. He may bound to answer for the commission of the crime. Arrest, it can be it is arrest by the person who committed a crime, or he or she may a suspect a crime. She or he was uh, arrested, and then it have in arrest, uh, they have a another warrant of arrest, which is called a John Doe warrant, which is it is a warrant of arrest without any name or description of the person who be arrested. So in Rule 112, the arrest, uh, they have a time of arrest. And time of arrest, maybe on day or night, or any time of the day or night. There's no time. Even this arrest is it is arrest. And in Rule 112, this have citizens arrest. And when a person to be arrested and in the it is in the custody of the police, who are the right to visit? Sino ang may karapatang bisitahin siya? So, person who made the visit, the person detained, which is the spouse or fiance or parent or child, uncle or aunt, nephew or niece, or any medical doctor that he need a medical assistance. So, in preliminary investigation and Rule 113, the arrest, that is what I learned. The how the preliminary investigation is conducted, and what is the arrest, and who are the people who need to visit to the people who detain or the person or arrested. And that's all, sir. Thank you.